Transfer of property. Before defining transfer of property, we will have to first define what is property. So, what is property? Property is a bundle of rights. Property is a bundle of rights. So, what do you mean by bundle of rights? See, whenever you have a property, you acquire a right over it. Say, for example, if you have an agricultural land, then you alone have the right to produce crops over it. No one else other than you can grow crops over it. So it's like you are having a right. Say for example, like you have a gold, then you have the right to wear it or use it or keep it in bank. So property is a bundle of rights. Like you have multiple property, then you have bundle of rights. So property can be movable, immovable, tangible, and intangible. There are four types of properties: movable, immovable, tangible, and intangible properties. So what is immovable property? In section 3, it talks about immovable property, but the TP Act itself does not define immovable property. To define property, we will have to look at General Clauses Act. Section 3 of 25 of General Clauses Act defines immovable property. So what is immovable property? Immovable property is anything that's land or benefit arising out of land or things attached to the earth or things so permanently fastened to things attached to the earth. So immovable property includes land, benefit arising out of land, things attached to earth, and things permanently fastened to things that attach to earth. So what is land? Land is any surface of above the earth, any surface below the earth, anything that naturally exists on the surface of the earth, or any human agency object like building, etc. Say for example, you have a piece of land, then everything that is above the surface of that land is yours, and anything that is below the surface of that land is yours, and anything that exists in the natural form in that land. For say for example, there is a lake or there are minerals in that land, then it will be yours. And any human agency objects, say for example, there is a building on that land, then that building also will be yours. Benefit of arising out of land. So what are the benefits arising out of that land? The property is divided into tangible and intangible properties. Benefits: tangible is visible property and intangible is not visible. So what is a visible property? Say for example, lakes, buildings, etc. are visible to your eyes, so they are tangible properties. Intangible properties which are not visible to your eyes, like example, profit is property but is not visible to your eyes. So any benefit that arises out of land, like if you have a house that you are given to rent and the rent that you get is a property, the benefit out of land. The if you have agricultural land and any crop that you grow over it and sell it, that is a benefit arising out of land. Things attached to the earth. So what are things attached to the earth? Things that are rooted to the earth, like for example trees are the things attached to the earth. Things embedded in the earth, like for example buildings that are embedded on the earth are things attached to the earth. And things attached to the embedded earth, like for example there is a building, it is an embedded building on the land, and the doors that are attached to the building are attached to that embedded building. That's what immovable property is. So what is movable property? Anything that is not a immovable property is a movable property. That's what it is definition. There is a case, Abdu Acharya versus Custodian Evacuate Property, Hyderabad, Deccan. It says that in this case, it was held that anything that cannot be moved without damaging the substance, then it is immovable property. Okay, anything which cannot be moved without damaging it, then it is an immovable property. So, like, for example, if you have a building, you cannot move it. If you try to move it, you will damage it. So, it's an immovable property. So, what is transfer of property? Section 5 defines transfer of property. Transfer of property is an act by living person. It's an act of conveyance by living person in present or future to one or more living person or to himself or both. Okay, a living person conveys or gives his property to one or more living person or to himself or to one or more living persons or to himself is transfer of property. It is an act of conveyance. It is an act of giving. So question is there in it, what is transfer of property? And they will ask like this question, is partition a TOP? Is surrender a TOP? Like that. So is a partition or TOP? The answer is no. In partition, it's not a TOP. You are dividing your interest, that's all. It is not a transfer. There is a case Mohar Singh versus Devi Charan. It is not a TOP, but it is a surrender of right for similar separate rights. Is a surrender a TOP? So what is surrender? Surrender is merging of lesser interest with a greater interest in such a way that the greater interest is not enlarged. Say for example, someone is having 1,000 rupees and you give your 10 rupees, add your 10 rupees to it. The greater interest is not enlarged in a heavy margin. That is surrender, and surrender is not a TOP. Is compromise a TOP? So what is compromise? Compromise is an agreement of settlement of doubtful claims between parties. So the people they gather together and they try to compromise on thing of the property. It is not a TOP. Is a relinquishment a TOP? Relinquishment is extinguishment of rights. The right just disappears. That is relinquishment. And a relinquishment is not a transfer of property. Is a family arrangement a transfer of property? So what is family arrangement? It is an agreement between family members to divide and hold family property. And a family arrangement is also not a transfer of property. Is charge a transfer of property? Charge is a securing payment of others, and charge is not a transfer of property. Is easement a transfer of property? So what is easement? Easement is a right of a owner arising out of a beneficial enjoyment. It's his own sole beneficial enjoyment. Like say for example, if you have a land, then it's your own beneficial enjoyment to construct anything on it. That is easement right. Whenever you acquire a property, you also acquire a easement right. And easement is also not a transfer of property. Essentials of a valid transfer. Now this is the most important topic in this unit. Essentials of a valid transfer. At least one question will be definitely asked within this. Within this, separate questions will also be asked. So what are the essentials of a valid transfer? The property should be transferable first, and it includes in section 6. The property, the law or object, there should be a lawful object or consideration for the transfer. The transfer should be competent to transfer. The transfer should be not opposed to the nature of the transfer. The transferor should be competent. The person who is transferring is called transferor. Transferring the property is called transferor, and the person who is receiving the property is a transferee. So the transferor should also be competent to transfer. The transfer should be made in prescribed form. There should be an act of conveyance, and there should be free consent. So essentials of a valid transfer includes section 5, section 6, section 7, and section 9. You'll have to write 4 sections in essentials of a valid transfer, and this is an important question also. So section first point, transferable property. The property should be transferable. See, a separate 10 marks question can also be asked within the section 6 itself. Within essentials of a valid transfer, there are separate questions that are asked. Section 6 first point, property of any kind can be transferred except. Section 6 goes on like the transferable property. Property of any kind can be transferred except. Spec succession. It talks about properties that cannot be transferred. Okay, section 6. Property of any kind can be transferred except spec succession. So what is spec succession? It is an heir apparent. It is an expectation or possibility of succession. Say if there is a son and his father has a property, then he is an heir to his father. He has a spec succession over his father. He can acquire property. That is spec succession. Right of re-entry. Spec succession cannot be transferred. Right of re-entry. Right of re-entry cannot also be transferred. So what is right of re-entry? Right of re-entry is a right that a lessor has against a lease on breach of re-enter on a breach of contract. So he can re-enter. Easement right. So easement also cannot be transferred. So what is easement? Easement is owners or occupiers beneficial enjoyment to do or prevent to do something on the land. So for example, if you have a land, then it is your sole right to do something on that land or to prevent someone from doing on that land. It is your sole authority or sole beneficial enjoyment. That is the right of easement. There is an example right of way. For example, if you have a house in a land and your land is so attached to your neighbor's house that you cannot go to your house without crossing the neighbor's property. So automatically a right of way arises over to the on the property of on the property of your neighbor. That is easement right of way. And a right of way cannot also be transferred. Restricted interest. So what is restricted interest? Enjoyment restricted by the owner. When the owner sells the property, he restricts the use of the property to the transferee. For example, A sells property to B and for B's use only. So A transfers property to B but puts a condition that only B should use it. Then it is a restricted interest. Right to future maintenance. Say if you have a right to future maintenance, then it cannot also be transferred. Right to sue. Say, for example, if A publishes a libel against B, A publishes some defamatory statements against B, then of course the B can sue A. But here only B alone can sue A for his defamatory statement because A has defamed B. B cannot transfer this right to someone like C of suing. Only B can sue. So right to sue cannot also be transferred. Public office. Public office or salary cannot be transferred, are not transferable. Say a government officer is there and he's holding an office, then he cannot transfer that office to someone else. Stipends and pensions. So what are pensions? Pensions are periodical allowance for past service. So if a government officer is there and he has passed his service, then he receives pensions, and pension cannot be transferred. It is a non-transferable property. The next clause, nature of interest, unlawful consideration, and legally disqualified transferee. Untransferable interest. Say for example, tenant. Tenant is an untransferable interest. Farmer on revenue. If a farmer is working on a land on revenue, then he cannot transfer that interest. A tenant who is living in his house cannot transfer his house, cannot sell his house. It's a non-transferable property. This is the biggest section actually in the entire TP Act. Section 6. The second point. The first point was transferable property, and it was discussed in section 6 that property of any kind can be transferred except succession, right of re-entry, easement right, restricted interest, right to future maintenance, right to sue, public office, stipends and pensions, and untransferable interest. This property cannot be transferred, and other than this, all properties can be transferred. That's what you have to think. The second point, lawful object or lawful consideration. It is also included in section 6H. Lawful object, there should be a lawful for essential valid transfer, there should be a lawful object or a lawful consideration. So what is a lawful consideration? It is defined in section 23 of Indian Contract Act. According to Indian Contract Act, if it is forbidden by law, then it is an unlawful consideration. If by nature it defeats the provisions of law, or if it is fraudulent, or if it provides injury to a person or property, or if it is immoral or opposed to public policy, then it is unlawful consideration. The next third point, competent transferee. The next essential of a valid transfer is competent transferee. The transferee should be competent to receive the property. See, transfer is the person who is receiving the property, and the person who is transferring the property is transferor. So transferee who is receiving the property should be competent to receive the property. Section 136 of this act disqualifies. So who are the persons who are not competent to receive property? So according to section 3, section 136 of TP Act, the judges, legal practitioners, Office of Court of Justice are disqualified from purchasing any property or doing any actionable claim. Okay, so these are the persons who are disqualified from purchasing from receiving property. These are the disqualified transferees. The fourth essential is it should be not opposed to the nature of interest. So what does it mean? There are two legal maxims. Res communis, which means things in natural form belongs to no one. And the next maxim is res nullis, not owned by anyone. Say for example, air, water, etc. They exist in the space naturally and they cannot be transferred. Someone cannot sell you air. Okay, if air is not transferable, untransferable property. The next essential of a valid transfer is the transferor should be competent. The person who is transferring the property should be competent to transfer the property. It is not mentioned in TP Act who is a competent transferor. For that, you have to look at Indian Contract Act. Section 11 of the Indian Contract Act defines the competent transferor as he should have age of majority, he should be of sound mind, and you should be not be disqualified to make the transfer, legally disqualified. The next essential of a valid transfer is it should be made in prescribed form. So what is a prescribed form? There are only two forms which can transfer property. One is oral transfer and other is written transfer. If you transfer orally, then it is an oral transfer. If you when you transfer, if you write it down, then it is a written transfer. Section 9 of this act defines oral transfer. Oral transfer is sometimes act separately also for 6 marks. So what is oral transfer? Without write, if the transfer is done without writing, then it is called oral transfer according to section 9. There are two modes of oral transfer. One is delivery of possession and the next is registration. What is delivery of possession? If in the delivery of possession, the writing is not necessary for transfer. For example, tenancy. If you give someone house on rent and if you go to collect rent, then there is no need of writing. Okay, you can just receive the tenancy. Mortgage by title deeds and any immovable property which is less than 100 rupees. If you are transferring it, then there is no need of writing. Any immovable property which is less than 100 rupees. If you're transferring it, then there's no need of writing. It's an oral transfer. The next is registration. For registration, it must be in compulsory be in writing, and when writing is necessary for transfer, it should be an immovable property above 100 rupees. If you're transferring an immovable property above 100 rupees, then it should be compulsorily be registered. Simple mortgage and other mortgage, etc., are the examples where you have to write it down while transferring the property. There is a case law, Avama M. Talwar versus State of Karnataka. It says that if writing is essential, then there is no other way. It was held that in this case, that if writing is essential for the transfer, then it should be done through registration only and should not be done through oral transfer. Short topic. So this concludes it. Essentials of a valid transfer. We saw transferable property. Under transferable property, we saw in section 6 the property which cannot be transferred. So other than that, all the properties can be transferred. And we saw lawful object and lawful consideration in the section in contract act. Then we saw competent transferee, the person who is not competent to receive transfer, judges and all. Then we saw transfer not opposed to the nature of transfer, that is the things that exist in the natural state cannot be transferred. The next is competent transferor. So the person who is transferring the property should be competent to transfer the property, and we have to take that from contract act, Indian contract act. The competent transferor, that is, he should be of age of marriage, majority, sound mind, etc., for transfer. And the next point we saw is made in prescribed form. It can be made orally or it can be made written, that you have to write. And the next is conveyance. So what is conveyance? You have to write the transfer of a property definition here. Section 5, conveyance. And the next is free consent. You just have to mention that there should be a free consent between both the parties for transfer. This is the most important topic, okay? It will compulsorily be asked. If not essentials of a valid transfer, then section 6 will be separately asked for 10 marks. You'll have to explain all section 6. Or this section 9 will be asked for 6 marks, oral transfer. The next is 6 marks topics. Condition restraining alienation. So what is condition restraining alienation? So for example, when you transfer a property and when you transfer the property, the transferor tells to the transferee that he cannot further sell the property. If you say, for example, if you are selling a land to someone and you tell that person that you cannot further sell that land to anyone, then this condition is totally void. Condition restraining alienation is totally void. That condition will not be valid. The person can further sell the land. He has authority. So you cannot put a condition like, no, you cannot sell this land further. No, you cannot put this condition. The person to whom you sell something, he has full authority to further sell it. So transfer condition restraining alienation is void except lease. There is an exception to this also, it is lease. So transfer with condition is conditional transfer. So for example, if you are transferring a property to someone and you put a condition, then it is called conditional transfer. There are two types of restraint, or there are two types of condition. One is absolute restraint and one is partial restraint. So what is absolute restraint? So for the application of this act, section 10, for the condition to be void, it should be an absolute restraint. So what is an absolute restraint? When you transfer the property, absolutely restraining the transfer from alienation. So you sell the transfer that no, you cannot sell this land further, then it is an absolute restraint, and you cannot put this condition. And for the application of this act, the condition should compulsorily be absolute. Illustration. You'll have to write an illustration in this. That is, A sells land to B, restraining B that he cannot further sell the land. Then that is absolute restraint. This is the case in this Rosher versus Kosher. A sells B some land and tells that he should sell that land only to A's wife for 1,000 rupees. But the value of that land is 10 lakh rupees. So this is an absolute restraint. So in this case, what happened was A sells his land to B and tells B that B can sell this land further only to A's wife only and for 1,000 rupees only, while the value of that land is 10 lakh rupees. So this is totally a void condition. You cannot put conditions like that. Even if you sell that land with this condition, the condition will be considered as void, and B can sell this land to anyone for 10 lakh rupees. That is absolute restraint. Restriction on a particular class, but there are certain cases exceptions also. Like for example, if you are uh, transferring to a certain class of person, certain group of person, the circumstances has to be seen. For example, co-partner selling to co-partner only. So when the partition happens, when the transfer of property is done to a Hindu co-partner, and then you can put the condition that the co-partner, if he is alienating his property, if he is selling his property, then he should sell to his co-partners only, fellow co-partners only. He cannot sell it to others. If he is even selling it, then he should first prefer co-partners and then sell it to others. That is a valid condition. If it's done to class of persons, then we have to see circumstances. So partial restraint next. So what is partial restraint? There is a restriction to some extent only, and it is totally valid and enforceable. Only absolute restraint is void, but partial restraint is valid. Like you restrict someone only to a partial extent, and it is totally valid and enforceable. You put only a partial restraint. Exceptions to these are lease and married women. Say if you transfer a property on lease, then you can put a condition that he cannot sell that property. It's a valid condition. And for married women, for example, husband gives property to her wife, and he can put a condition that she should not alienate it. It's a valid condition. This topic can be asked for 6 marks. The next topic is transfer for benefit of unborn person. Section 13. So who is an unborn person? Say transfer of property only deals with living persons only. It does not deal with dead person. So what does it mean by unborn person? Unborn person is a person who is in his mother womb. He has not born yet. He's still in his mother's womb. That person is unborn person. So the question is, can we transfer property in the name of an unborn person? The answer is no. We cannot directly transfer the property to in the name of an unborn person. So are there any ways to transfer property to an unborn person? Yes, but it should satisfy two conditions. The first condition is prior interest on living person. You cannot directly transfer property in the name of an unborn person, but instead you can transfer property in the name of a living person, and the living person, when the unborn person is born, he can transfer the property to him. That's what it says. Prior interest on a living person. So you have to first transfer it on a living person, and then absolute interest is transferred. So we'll discuss one by one. Prior interest. So what is the prior interest? For a valid transfer, the following three conditions should be satisfied. There should be a prior interest on a living person. So you should first transfer the property to a living person, and the unborn person bonds before the expiry of the prior interest. And before the living person dies, the unborn person should come into existence. He should come into life. And after the death of the prior interest of the person holding the prior interest, after his death, the property is automatically transferred to the unborn person because now he's in existence. Okay, the property is transferred to a living person, and when the unborn person should come into existence, he should born before the death of the prior interest, before the death of the person who is holding the prior interest. And when the person who is holding the prior interest dies, the property is automatically transferred to the unborn person. This is a complicated concept actually. Illustration. There's an example. A transfers his property to X for life. Then the X transfers his property to Y for life. And Y dies, and before dying he transfers his property to Z for life. And then Z gives the property to his children. So X, Y, Z are the living persons. That's how it flows. First you have to transfer the property in the name of a living person, and when the person dies, it automatically is in the name of unborn person. Absolute interest is transferred. The whole of the remaining interest should be transferred. So what is the whole of the remaining interest? So entire interest minus prior life interest. See, when you transfer the property in the name of a living person, the living person before the unborn person is born can utilize the property for himself. He can use that land and get benefit out of that land. He can even take profit out of the land, and but he should spend all the money on maintenance. He should properly maintain it. So minus that, he should transfer entire property to the unborn person. Only that then it is valid. That's all for this unit.